So I teach the undergraduate and postgraduate health law courses at the ANU, and for 20 years I've run a moot in the ACT Supreme Court, which is set in a utopian future world where all the roads and houses and bridges do photosynthesis instead of using plants or exploiting them as slaves. So it's really a thought experiment in an ideal social contract, and I get the medical students to be the expert witnesses and the law students from the ANU to be counsel. They explore issues of liquid democracy, rights of nature, corporate marriage in this world, which is set on misdemeanours occurring at the Uqbar General Hospital and its surrounds. And it's part of a program that I'm doing to create a culture where people think that it's possible that humanity may survive indefinitely into the future as good stewards over the planet. Well, I write the problem every year. I create some malefactions, usually of the director of the Uqbar General Hospital, Jack Veronsky. So this year, Jack Veronsky decided to turn the meadow around the hospital into a monoculture, and in order to do that, he wanted to spray organophosphate insecticide over the meadow, and someone got poisoned with that. And so the law students then allocated a group of medical students to be the expert witnesses. They work up the witness testimony of their medical students, and then in the moot, each law student gets to address the bench for 3 minutes on issues related to the problem. They get to cross-examine the witnesses from the other side, examine in chief their own witnesses. So they get about 10 minutes in front of the bench, each of the 12 law students.
This is analogous to the case at hand, and this law should be applied to Dr. Veronsky. However,
in the moot, I was co-counsel for the defendant Jack Veronsky and Mano Cross, and we prepared by holding team meetings and just setting up communication and working with the medical students to prep them for the moot, and helping them for examination, cross-examination, and just really getting on board the medical knowledge of organophosphate poisoning. It was really just a team effort where we would delegate the roles of different research aspects and prepare each of our witnesses, so then we could come together as a cohesive team at the end.
We had both Justice Elkaim and Associate Justice McWilliam on the bench hearing our case, which made it incredibly nerve-wracking, because it wasn't just our marks at stake, but also what would these judges think of the depth and weight of our legal arguments. So having them in front of us and also hearing their feedback at the end definitely gave the moot a greater significance than if it were just in the classroom.
The law students love working with the medical students. I think they get a chance to see how a different group of students, some of them a little bit older, how they think about the sort of problems they form lasting friendships. I think they really enjoy actually getting a chance to practice their legal knowledge. You know, getting a witness ready, and getting information out of them, and then cross-examining the opponent's witness, and getting some of them really, you can see, just really take to this, and you can see there's something that goes off in their mind and they think, I want to do this.
I realised that I'm interested in how law interacts with people and society, and particularly health law in the context of Australia, and when you compare that to places like the US, that is at a really obvious place where society and their needs intersects with the law, and what that can enable or what that can restrict. So also by engaging in the moot was like a real life example of how myself as a prospective lawyer can engage with these real world issues possibly in the future.